Hello, everybody. Today I'm going to talk about the issue of school fees in Delhi, which has been there during this COVID issue. Parents have been putting their stand that they are not able to pay the fee, and since the schools are not working, so only the minimal fee of tuition fee should be charged from the parents. But schools, they have a different story to tell. They have to say that they have an infrastructure, a staff to support non-teaching staff and the teaching staff. What actually happened was that on 24th of March 2020, the central government announced a nationwide lockdown and which led to various economic cascading effect. Various businesses were suspended. Some businesses like tourism, airlines, they were completely shut down. And so this led to various financial problems to a common man. Now, during this period, the academic session of the schools was also starting. When the academic session started, the schools started demanding the fees, which is in the usual course. So various parents and parent bodies they started writing to these schools and also to the Directorate of Education that till the lockdown is going on, till then the fees may not be charged, and at least if it is charged, only tuition fee may be charged from them. Now, various writ petitions were filed across the country, and also in Delhi High Court, various writ petitions were filed. Now, responding to this clarion call by the parents and parent bodies, the Directorate of Education on 18th April 2020 issued a notification where it observed that some schools have increased their fee during the academic session of 2021 and that the schools are not providing ID and password to various students who have not given the fee, and so they were debarred from attending the online classes, and the salaries of teachers were cut up to 40 to 50%. It was also observed that due to early closure of schools in the wake of COVID-19, the expenditure of co-curricular activities, sports activities, transport and other development related activities is almost nil. And the private schools were directed that they shall charge only tuition fee and they will not increase the fee. The development fee and the annual fee they will charge on pro rata basis when the lockdown is lifted. And in Naresh Kumar versus Director of Education, Delhi High Court lauded this initiative of the Directorate of Education and said that it strikes a correct balance between the legitimate concerns of the institutions and the parents. Now, so far so good. Now, what happened after government started announcing the unlocked phases from June 2020? These schools they started charging the development fee and the annual fee, and again these parent bodies they approached these schools and they also filed a writ petition before Delhi High Court. They demanded that schools should follow the notification which was given by Delhi High Court in the way that the COVID situation lockdown is still there and they are still not coped up with the financial problem which they are facing. Now these schools they also filed a writ petition before the Delhi High Court which was titled as Action Committee Unaided Recognized Private School versus Directorate of Education. After this matter was argued before the High Court, now High Court has delivered the order on 31st May 2021 and it has said that the power of Directorate of Education is limited to check that the schools don't do profiteering and not to spell out the rules to regulate and control power to collect the fees. That means they can only check that the schools they are not profiteering and they can give, but they cannot go into what the fees school should charge. That is only a prerogative of the school. Now, in the absence of a finding of commercialization of education or exploitation, the Directorate of Education cannot indefinitely cut down the established fee or restrain a school from collecting a portion of the existing fees. So High Court recognized various subheads under the development fee and annual charges and went on to observe that some of these charges are also those charges which the school incurs also when the school is shut. So these development charges and annual charges It is not that the school is profiteering on these. This is what this court has observed. Now, and it is not the case that the schools are profiteering for collecting the development and annual fee. Though I want to add one point over here that schools, as it appears from the judgment, they had not produced any audited accounts to show how much expenses they have incurred towards these development charges and annual charges. Now, Delhi High Court has also quoted a recent judgment of Supreme Court where similar issue has been dealt by Supreme Court also. And Supreme Court has stated in the Rajasthan schools case that it is not open to the state government to issue directions in respect of commercial or economic aspects of contract between the schools and the parent and exercise powers in guise of management of pandemic situation or to provide mitigation to one of the two private parties at the cost of the other. And also under Article 162 of the Constitution does not empower the state government to decide what should be the fee structure. This is a prerogative of the schools. So basically the schools, they cannot go breach into the power of the schools to decide what should be the annual and development charges. Now, depending upon these judgments and the various other judgments which were decided by Delhi High Court regarding the commercialization, profiteering, and what is the right of the schools, Delhi High Court struck down the two notifications of the Directorate of Education, and it has taken directives that were passed by Supreme Court in the Jodhpur schools case and has applied it to the Delhi schools case also. And now these directions are: firstly, schools will collect annual fee from students of academic year 2019-20 by providing a deduction of 15%, because court has also observed that it is correct that the schools are physically not working. So taking into consideration broadly, they have decided to cut the total fee by reducing the fee by 15%. Now the amount, second point is that the amount will be paid in equal monthly installments by students starting from 10th June 2021. Then next is schools can decide on giving further concession to the students. Schools will not debar the students from taking online classes, those who have not paid the fee, and they will ensure that no student is withheld in the board exams for non-payment of this fee. Now, a few questions arise in my mind over here. That the school showed that there are certain heads of expenses which the school incur when the school is shut. Though reasonably, the Honorable Court has made a deduction of 15%, given a concession of 15%, and they have justly done this. But still, schools should have produced their accounts to show how much expenses they have incurred last year on these expenses, and should have reasonably given a profit margin. And the second question is, court has also observed that the schools can decide on giving further concessions. Now when the schools, they are already fighting for their fee, how can they be expected to further give concession? I think the court has very rightly given the spirit to the schools that they should consider, in the light of this pandemic, they should consider giving concession. Now it depends upon the school that they have a right only to fight in the court for the fee, or they also have some philanthropic duty towards the society also in this unprecedented situation. Now the third thing is, it is correct legally what court has stated, that state government cannot breach into the line of deciding the amount of fee which the schools have to collect. But looking into this unprecedented situation, which could not have been contemplated when the Delhi State Education Act was enacted, when it was created, that a pandemic of this nature will occur in future. So the thing is that at least previous years fee, development fee and annual fee, it may have been waived. And in future, the schools should also look that whether this annual and development fee is really required. So this is the basic question which arises from the schools also. They have been collecting fee from so many years. So waiving off a part of fee for 1 or 2 years, does it really hamper the working itself of the school? Can the schools not work on no profit no loss basis when some people, they are not even able to earn there for the expenses also? And the point is that schools, they regularly teach about the philanthropy, they talk about social help, but during the distress for the people in distress. But during this actual phase of distress to the society, when the people are fighting for the basic incomes, so shouldn't the school also come forward and give a philanthropic step in the society to give a example, to set an example for the students who are studying there, to show that when the priority comes in society, it is not the fee which matters, it's the morals and the social help that matters. This this gesture of fighting for fee in the courts, does it give a very good message to the students who are fighting, who are studying in these schools? And isn't this an act of confusion for those students who are debarred from taking online classes? That there is a question in their mind also, that why we have been debarred just for the financial reason. So what is the priority? The children in their tender age, they have come to learn what is the priority in life. Is it social work or the monetary gains? So I think these institutions, they should work practically on no profit no loss basis and earn only that much to sustain themselves. And it is their priority to set the fee, but there is also a duty, a moral duty, not a legal duty. They have a moral duty to show that they set a good example before the students who are studying with them. Thank you. I hope you people like this video and do subscribe to my channel. Till next time, we'll talk about next subject. Okay, bye bye.